the publication a digest. I'm not going to say too much about it because we do have Fergus who's going to elaborate a little bit more on that. Just for a point of order, we are going to start with a welcome from our executive director, and then we are going to have a panel of speakers. I see Ms. Michelle Germain over there. If you want to join us on the panel. We have 4 distinguished speakers this morning who will offer a reflection on the compilation, and in some instances who will offer even deeper insights into the cases that have been highlighted in this compilation.
Can you check
So, let me just start by saying that, there's been a long struggle of indigenous peoples around the world against colonization, forced assimilation, and systemic discrimination. And this resulted, of course, in the adoption of the United Nations Declaration on the Rights of Indigenous Peoples. And this declaration, as we all know, sets out the minimum international standards for respect and recognition and protection of the rights of indigenous peoples. However, despite this milestone achievement, as you know, we continue to be violated in law and practice in many parts of the world, as we heard all week this week. Still, we notice that more and more legislation and jurisprudence are affirming the rights of indigenous people, especially to their lands, territories, and resources, to self-determination, and to their cultural heritage. Many of these legislation and jurisprudence are being issued by different authoritative bodies in line with the United Nations Declaration and with the Universal and Regional Human Rights Treaties. UNDRIP, Indigenous Peoples' Rights International, is therefore issuing this digest as a compilation of legislation and jurisprudence in relation to indigenous people's rights at the international level, so the UN system and perhaps others, and at the regional level, the regional human rights bodies, and at the national level, the national courts. Among other things, the cases in the digest illustrates the expert mechanism on the rights of indigenous peoples' conclusion that, and I quote, many of the rights contained in the declaration are already guaranteed by major international human rights instruments and have been given significant normative strength, including through the work of the treaty bodies, regional and national courts. So we believe at UNDRIP that it's important to share this information with indigenous peoples, with our allies, with others, in order to drive the increased awareness and understanding about indigenous people's rights as an integral part of the human rights law, where states have the duty to recognize, respect, and protect, and fulfill the rights in domestic laws and practice. With that, I offer the floor to Ms. Joanne Carling, our Executive Director, to welcome you and to open the session. Thank you.
Is it on? Yes. I'm sorry, the problem is I don't see it here. Good morning to everyone, and thanks Christina for that background. I also want to acknowledge that this event is organized with the Office of the High Commissioner, and who is also with us as a representative will be speaking. And also I welcome all our speakers here, and I'm very happy that we have speakers from different regions who will also be reflecting on the jurisprudence on upholding the rights of indigenous peoples in treaty bodies, decisions and recommendations of treaty bodies or regional and national courts. But just to begin with, I just want to briefly introduce our organization, the Indigenous Peoples' Rights International. It's relatively a new organization established during the pandemic. So notwithstanding that, we are a global indigenous-led organization working on the issue of criminalization, it became apparent that there is a gap in terms of a more systematic and sustained manner on how we address this systemic challenge for indigenous peoples across the world on the issue of criminalization. So this is the focus of IPRI, along with, of course, violence and human rights violations with impunity, because all this comes together. The issue of criminalization, human rights violations with impunity, and violence against indigenous peoples as really the serious problems we are facing in relation to the respect, recognition, and protection of our rights, both our individual rights and collective rights. So IPRI works with organizations at different levels. We have partners at the national level and also at the regional level and global level. We work on the thematic area of business and human rights, because there's increasing violation of indigenous peoples by business in of course, collaboration with states. We also work on the issue of criminalization in conservation, and we anticipate that this will be a very serious problem if the target of 30 by 30 is going to be implemented the old way, or following still the fortress conservation. But it can also be an opportunity to make the needed changes for us to effectively reach that target. And then we also work on the issue of incarceration of indigenous peoples. As you know, indigenous peoples are disproportionately represented in almost all jails across the world where there are indigenous peoples. From US, Canada, Australia, to Indonesia, Cambodia, DRC, and also in Latin America, Chile, it's indigenous peoples that are in jail simply for practicing our livelihoods, our traditional occupations, or defending our rights to our lands, territories, and resources. So just to say that these are the issues that IPRI is working on. And finally, the reason why we decided to come out with this compilation on laws and jurisprudence upholding indigenous people's rights is because we want that this set the standard of how states and other actors relates to indigenous peoples, and that this standard is now being increasingly recognized and upheld by national courts, regional and global, using the UN Declaration on the Rights of Indigenous Peoples. So that's the norm that we want to see that takes place, the implementation of the UN Declaration on the Rights of Indigenous Peoples, because it encompasses the recognition of our rights and the framework on how different actors should relate with indigenous people. So that's the context of why we took on this compilation. For me personally, it has been very enlightening, reading through decisions of courts, decisions of regional bodies, and decisions of treaty bodies and other UN mechanisms. It really sharpens our understanding on how our rights is going to be implemented, from both the substantive elements of our rights and how it should be recognized and respected by different bodies on the ground. So I would encourage you to really read this digest. We simplified it as much as possible so that it's less legally to layman like us. So with that note, I want to pass it back to Christina. Thank you.
Thank you so much, Joanne. And now I would like to introduce to you the person behind all of this, and has done incredible work to help us to, as Joanne said, take away the technical legal language and put it in a format that's simple and easy to understand by the layperson by, the indigenous activist by, all of us that are trying to understand how better to advocate and how better to implement the declaration. So unfortunately, he wasn't able to be here with us. He had to leave yesterday. He's been here all week prior. And so I want to introduce you to Mr. Fergus Mackay. He's our senior legal counsel at the Indigenous Peoples' Rights International, and he'll talk to us a little bit more about the compilation itself, in particular, or specifically this publication.
Good morning, everybody. I apologize for not being with you in person.
You can hear it well with this.
But I hope the rest of the side event goes very well. Issue 4 of Xanharu Digest has one international case and 2 regional instruments and 6 national proposals. The first case was decided by the Commission on the Rights of the Child just last month in June. Concerns a 13-year-old Indigenous girl. I won't go into the details because they are disturbing. One of my colleagues, after reading the decision, said that poor girl was failed by everyone, which is certainly true. It mostly concerns the right to health, prohibition of discrimination, and inhumane treatment. The main relevance of the decision is that the committee deemed that her status as an Indigenous girl was also relevant, both as an intersecting form of discrimination and as a more generalized intersection between the Convention on the Rights of the Child and the Indigenous Peoples' Rights Framework, whereby the girl has both individual and collective rights that may be relevant, including the formulation of remedies. It also suggests that the same conclusion should be reached with regard to guarantees against torture and inhumane treatment, taking her Indigenous status into account in determining the nature and extent of that inhumane treatment or torture, including her dislocation from her community, which is relevant to assessing pain, anxiety, and suffering for those purposes. Right? Complements prior decisions of the Human Rights Committee against torture, although, as for this decision, there wasn't really a full airing of the Indigenous issues. There's a bit of a feeling there was a missed opportunity to further develop some of those issues, including the collective aspects. The regional instruments include a precautionary measures decision adopted by the International Commission on Human Rights, which protects an Indigenous leader in Colombia whose life was threatened. The Commission therein explained that attacks against Indigenous peoples' authorities, quote, have an impact not only on the direct victim, but also on the peoples and communities themselves, given the important functions they perform and their central role in the defense and preservation of ancestral culture, close quote. This collective aspect is really important and is often lost in discussions related to human rights defenders and the like. And it's very welcome that the Commission is raising this issue. The Commission also said that the person in question has the right to continue their work in defense of their people and their lands. And the Commission urged Colombia to adopt protective measures so that he can, quote, continue to exercise his Indigenous leadership without being subjected to threats, intimidation, harassment, or acts of violence, close quote. The second regional instrument is a bilateral agreement between Canada and Mexico, which affirms the need to respect and promote the inherent rights of Indigenous peoples, as recognized explicitly in the UN Declaration on the Rights of Indigenous Peoples. Guiding principles include adopting an approach based on partnership between states and Indigenous peoples, and recognizing the special relationship of Indigenous peoples with lands, territories, and natural resources. Collaboration focuses in part on supporting Indigenous-led processes and advancing self-determination by supporting Indigenous peoples to engage freely in all traditional and other economic activities, and by determining strategies and projects for rights development, words taken pretty much from the Declaration itself. Right? National cases are from the USA, Guyana, Canada, Peru, and Australia. First concerns a claim decided by the U.S. Supreme Court in a case that had challenged the constitutionality of the Indian Child Welfare Act. It was argued that it discriminated against non-Indigenous peoples who are seeking to adopt or foster indigenous children on the basis of their race, or was racially discriminatory against white people. So it challenges the long-standing view that the federal Indian law is based on the political sovereign character of the regulations rather than racial distinctions, thereby permissible and not running afoul non-discrimination and equal protection laws. Right? The court rejects the case on a technicality, basically for lack of standing, meaning that a similar case could be heard, similar challenges could still be brought in the future, and one judge even suggested that such a case should be brought because he was willing to entertain the equal protection arguments, which would be a very serious departure from a long history in the U.S., long line of jurisprudence in the U.S. The Peru case will be discussed later, so I won't talk much about it. Briefly, it's important internationally because it specifically invokes Articles 26 and 27 of the Declaration as part of its finding a right to title of indigenous territories, a right to title, basically, is what they said. Reaffirms the jurisprudence of the Inter-American Court that grants that concessions in or affecting indigenous peoples' territories are unlawful until they've been fully demarcated and titled. That renders a large percentage of concessions across the Americas unlawful, technically, because they're in indigenous territories that haven't been titled and demarcated. The same can be said for all steward protected areas and other activities as well. The Guyana case was decided by the trial court, where the High Court is the lowest court in Guyana.
Thank you very much for allowing us to just bring to you the video of Mr. Fergus Mackay. He elaborated a little bit on some of the cases in this publication, but now I would like to invite our distinguished panelists to share with us their reflection and give us their perspective on the compilation itself, in some instances, specific cases. I would like first to give the floor to our collaborator at the Office of the OCHR, our colleague here, Mr. Arturo. Please.
Thank you so much. Good morning. My name is Arturo Requesens. I work for the Office of the High Commissioner for Human Rights and Indigenous Peoples and Minority Section. It's a pleasure to be here with you. And first of all, I would like to thank IPRI for this very kind invitation for this side event, for the launch of the 4th edition of Xanharu, Digest of Legislation and Jurisprudence, which in Xanharu means Pa in Purépecha, one of the indigenous languages, indigenous peoples in Mexico. The digest produced by Fergus Mackay with IPRI, in my view, is one of the most important tools to support indigenous peoples, lawyers, and for also to advocate to develop policies to advance the implementation of the United Nations Declaration on the Rights of Indigenous Peoples, as it contains the most recent developments at the universal, regional, and national levels on the implementation of the Declaration. In my view, Fergus is one of the lawyers that has worked the most on indigenous people's cases, litigating at the international level, but he also knows a lot about national legislation. So whenever we organize training, we always try to invite him. And we always look at the digest also to provide examples of how UN tribunals and UN instances, mechanisms, human rights, and national tribunals have applied the UN Declaration on the Rights of Indigenous Peoples. So this is really that's why it's a real pleasure for me to be here today. The work done by indigenous peoples, lawyers, or advocates has advanced in the implementation of indigenous peoples at all levels, one case at a time. And it is by using the UN Declaration on the Rights of Indigenous Peoples and quoting it as a way of making it more visible and make sure that tribunals look at it and apply it. As we all know, law is not static and it evolves with the time. So if we really want the declaration to be implemented, we need to use it. And we need to use it in all our exercises, including policy, of course, but also when we are dealing with the specific cases at the local, national, regional, and international levels. That's why I believe that knowing these latest developments is really important and it's crucial, so we can quote them and we can see how these standards have evolved. Fortunately, I've seen that these standards are evolved for good, and little by little, more tribunals and more mechanisms are using the UN Declarations on the Rights of Indigenous Peoples. That's why I want to congratulate IPRI and Fergus for this publication, and I hope they really continue with this effort. I also noticed, as it was mentioned before, that it has been simplified. Because in previous years, the compilation produced by Fergus basically had the whole jurisprudence. So it was like a really, really long document, and sometimes, I mean, it's very, for those who are passionate about cases and looking at details, it's really interesting to see all the arguments. However, well, I think it's really also good the fact that it was simplified. Coding basically the most important paragraphs of the decisions, and of course, whenever we want to look in more detail, we can always look for the specific sources. So I applaud also that it has been simplified, and I really want to encourage IPRI and Fergus to continue with this exercise, which in my view is really important. Fergus was already making reference to cases. I don't really want to elaborate more on them, but it is really interesting to see that basically, although many people, and that's something that Fergus always mentions in his training, is like, do we need or we don't need an international treaty or another international treaty on indigenous people's rights? It's really good to see that basically the indigenous people's rights at the national level have been interpreted in light of the UN Declaration on the Rights of Indigenous Peoples. Because this is something that doesn't happen with all the declarations. So, this is a really good step forward. And the only way for us to keep working the implementation of the declaration is through using it and also litigating and arguing based on the articles of the declaration. I'm not going to enter into issues whether we should only use the declaration or the ILO Convention 169. I think we should always look at the most advanced standards, and the most advanced standards are in the declaration. But I would also look at, if we are arguing cases, I would also look at, of course, the articles containing ILO Convention to see whether they can also support and be useful for our arguments in order to strengthen our position. So, although some judgments might be related to cases in different countries at the national level, it is also important that we use those criteria even at the national level in our cases, because this is also a way of reflecting how this is evolving internationally and worldwide. The last thing that I want to encourage is, I mean, this is a really good compilation, but unfortunately, not so many judges, not so many lawyers know about all this jurisprudence. So I think it is really important to try to strengthen the work with judges at the national level, and we are doing our part, of course, at the international level with UN mechanisms. But the truth is that at the national level, it exists still a very big ignorance about the UN standards on the rights of indigenous peoples. That's why we need to keep, I mean, this tool is really important, but we can also use it to provide training to judges and advocates at the national level to use it more broadly. Thank you so much for the invitation.
kind of reflection tool. I think that, again, it's very important to get the feedback from the general public and those that are using this tool so that we can further improve. And the idea is always to make it more accessible so that it can become a real instrument, a real tool to advance the declaration itself. So now I want to turn to our other speakers. I want to invite first, and my apologies if I don't pronounce your name properly, Ms. Marjolaine Etienne, President of the Quebec Native Women. I'd like to invite you to the floor.
Bonjour tout le monde, mon nom c'est Marjolaine Etienne et je suis de la nation Innu, de la communauté autochtone Majorelle. J'ai la province de Québec, dans les grands pays du Canada. En fait, j'ai occupé des fonctions de près de 15 ans dans la communauté, à intervenir aux communautaires, à aider les femmes suivies de violence, et aussi les aînés, les jeunes, les hommes aussi également, comme certaines des interventions de relations ouvertes, le soutien à l'accompagnement des services appropriés dépendamment de leur besoin. Et par la suite, j'ai fait près de 15 ans de politique dans la communauté, comme chef des affaires extérieures. J'ai eu l'occasion aussi également de pouvoir travailler pour le ministre des Affaires extérieures au Québec, en matière effectivement de faire connaître les enjeux, les réalités des communautés autochtones au Québec, qui sont dans près de 54 communautés à de différentes nations, donc près de 11 nations. Et puis, par la suite, j'ai été aussi logée dans le programme du fonds volontaire, donc j'ai participé en 2018. Je suis rendue ici avec nous. En fait, je dirais, je suis présidente de Femmes autochtones du Québec depuis décembre 2021. En 2024, nous allons célébrer le 50e d'existence de notre organisation autochtone du Québec, qui représente un bon nombre de femmes au Québec. Donc, le conseil d'administration représente l'ensemble des différentes nations au niveau du Québec. Il y a 11 nations, donc chaque femme provient de chaque nation. Et nous avons aussi un siège qui est attribué à une femme autochtone qui vit en Égypte. C'est important de pouvoir avoir aussi les préoccupations et les besoins des femmes qui ne vivent pas dans la communauté, qui de meilleures conditions, si on veut, pour elles, pour leur famille, effectivement. Sinon, c'est par le manque de logement aussi également, qui sont dans l'obligation de se loger dans les milieux urbains. Donc, en décembre 2021, lorsque j'ai été élue, j'ai porté une grande réflexion à l'égard d'une vue d'ensemble du Québec, des femmes de différentes nations, à savoir effectivement quels seraient les enjeux dans le cadre de mon mandat. J'ai un mandat de près de 3 ans, donc c'est court. Donc, il était nécessaire pour moi de pouvoir cibler les orientations et priorités pour atteindre des résultats concrets et répondre à certains besoins des femmes des Premières Nations et du Québec. Donc, tout de suite, j'ai mobilisé les membres du conseil d'administration à avoir une réflexion commune et à dégager ensemble les orientations qui nous permettraient de répondre à des besoins des femmes des Premières Nations. Donc, une sortie, d'autres orientations, c'est plus de nature administrative, donc c'est une rejoint. C'est celle, effectivement, de développer le leadership ou l'empowerment des femmes. c'est une belle orientation qui, je sens, que les femmes en action sur la se seraient appropriées leur rôle et leur responsabilité qu'elles ont perdues, sont tout à fait perdues, mais qu'elles ont été un peu mises à l'écart en raison de la colonisation, de la mise en place du système d'émancipation et la loi sur la santé. Donc, par la suite, j'ai entre les mains un outil qui s'appelle la planification stratégique, qui me donne une orientation claire pour arriver à la fin de mon mandat. Maintenant, suite à une discussion avec les femmes des différentes nations au Québec, il est clair que la mise en œuvre de la Déclaration des peuples autochtones, d'un point de vue gouvernemental plutôt provincial, et non au niveau fédéral, parce que fédéral, le gouvernement, c'est un ensemble qui regroupe l'ensemble des provinces du Canada, mais c'est au niveau du gouvernement provincial, dont je fais référence à celui du Premier ministre actuel, M. Legault. Il est clair que la mise en œuvre de la Déclaration des peuples autochtones n'est pas sur sa table de travail. Encore moins la question, parce qu'on travaille effectivement pour l'ensemble des femmes, donc j'ai 2 articles à ce moment-ci qui concernent les femmes autochtones, l'ensemble des femmes autochtones aussi au niveau international, des droits qui concernent les articles 21 et 22. Donc, mes démarches et mes actions avec les femmes et les organisations autochtones et autochtones du Québec sont axées, sont appuyées sur des actions de fait concrets et puis sur des rapports qui ont été rendus publics à l'égard des femmes autochtones, dont notamment celui le plus récent, c'est celui de la civilisation imposée. Et puis, un autre rapport que l'on a sorti, c'est le rapport Corona. Il y avait eu une situation en 2019 concernant les jeunes femmes de la nation du Québec, où, à la suite de non-soins ou d'intervention appropriés, elle est décédée. Et ça a circulé effectivement sur le fil d'actualité de Facebook, parce qu'elle s'est filmée avant son décès. Donc, on pouvait entendre les infirmières lui dire des propos assez racistes, assez raciales, assez discriminatoires à son égard. Et puis, il y a eu effectivement une enquête, le rapport du coroner a déjà été mentionné. Donc, sur ce, vous voyez un peu les enjeux des femmes de condamnation quand je parle au niveau des femmes, mais je fais référence aussi au niveau des familles, parce que les femmes autochtones sont des ouvrières, sont des familles, donc elles sont des enfants, des aînés, des hommes. Et puis, là-dessus, c'est que bon, ça me permet effectivement de pouvoir mener des actions sur les rapports, des articles aussi également, les articles 21 et 22. Donc, mon travail ne fait que commencer au niveau du Québec. Il me reste encore des étapes à pouvoir faire en sorte de pouvoir faire avancer la cause des femmes qui, à mon avis, lorsqu'on touche à une femme, on touche à des enfants, on touche à une famille, et on touche à une collectivité. Quand on touche à un enfant, on touche à des mères, on touche à une famille, on touche les aînés, on touche à une collectivité. Donc pour moi, effectivement, le fait qu'il y ait du racisme, une discrimination systémique, d'ailleurs, en décembre 2022, les femmes autochtones du Québec se sont mobilisées devant l'Assemblée nationale du Québec pour pouvoir manifester et revendiquer leurs droits. Le droit, effectivement, que le gouvernement du Québec puisse reconnaître, une fois pour toutes, les discriminations et le racisme systémique, de travailler sur cette source de problèmes qui va permettre effectivement de pouvoir régler ou de mettre en action ou d'identifier des pistes de solutions pour qu'on puisse effectivement arriver que ça puisse diminuer le racisme et la discrimination systémique dans le système. Parce que quand les femmes vont utiliser des services de soins, elles vont pour accoucher dans le milieu hospitalier, elles accompagnent les enfants, elles accompagnent les aînés et les hommes. Donc c'est elles qui sont devant, qui sont sur la ligne pour pouvoir recevoir les soins nécessaires et avoir de meilleures conditions de santé. Et puis, un autre exemple, si je pourrais apporter, c'est que, pas plus tard en juillet, si je ne me trompe pas, c'est que j'ai été invitée à rencontrer le nouveau directeur de la sécurité publique de la ville de Montréal. Il y avait d'autres organisations autochtones et américaines aussi qui avaient été invitées. Et ils nous ont fait part en amont, avant qu'ils puissent prendre la parole devant une conférence de presse, qu'il avait mentionné effectivement qu'il y avait du racisme et de la discrimination à l'égard des services policiers. Donc, c'était pour moi une avancée, une action d'un service policier qui faisait en sorte qu'il va travailler sur cette source de problème-là, mais aussi avec le service à lui qui est le service policier. Donc, c'est une longue bataille pour arriver effectivement à ce qu'il y ait des actions concrètes, des démarches de consultation, des démarches pour argumenter aussi également les causes, donc de faire entendre les causes aussi également. Mais il reste quand même un outil essentiel, puis primordial, je dirais, c'est celui de la mise en œuvre de la déclaration des droits de l'homme. Et puis, je suis contente d'entendre que ce faux, quand il parlait, c'est prendre tout l'outil au complet, c'est un bon morceau, hein? C'est la façon dont on fait, mais prendre quelques articles qui nous concernent, d'y travailler fortement et avec des alliés aussi, que ce soit politique ou autres, organisations autochtones, et même en autochtone, parce qu'on a quand même un bon appui, je dirais, dans l'automne au niveau du Québec, à travers tout ça, à travers l'enjeu que je suis en train de mener pour la cause des femmes. Je ne me sens pas tout seul. Donc, je me dis qu'il y a des alliés, il y a des appuis, il y a des rapports. Il y a eu des faits, malheureusement, comme j'ai cité tantôt, le décès tragique de Mme James Échaquan, qui fait en sorte qu'il ne faut pas fermer les yeux et il ne faut fermer non plus fermer les yeux, puis donc de travailler fortement encore avec le gouvernement du Québec, encore marteler, surmonter les enjeux. Et arriver à ce qu'il y ait aussi un réel processus de réconciliation. C'est des grands mots, j'y crois, hein? Moi je crois fortement à la réconciliation, mais c'est en menant des petites actions concrètes qu'on va y arriver, et ça ne se fait pas tout seul, mais je crois aussi que l'outil de la déclaration est important dans cette action-là. Merci.
Thank you so much for that reflection. It's important to recognize as well, of course, that the issues of indigenous people and behind, as was already mentioned, it's a struggle. We have to struggle against the discrimination as indigenous people, but in addition as indigenous people. And so that's really, really important to highlight. I thank you for that reflection. I know that we are running a little bit with time, so I want to offer the floor to Ms. Susie. She's an indigenous lawyer and activist from Peru. Susie, thank you for being with us and thank you for your reflection.
Gracias. Buenos días a todos y a todas. La comunidad cristiana, mi nombre es Susana González, soy invitada del Foro Supremo de la Comunidad.
agradezco por la oportunidad de participar en el evento tan importante. También quiero agradecer a Cristina y a Iti por la invitación a estar en este evento. También aprovecho la oportunidad para felicitar por el trabajo realizado. Este documento es muy importante porque recoge varias sentencias y será seguramente un material infaltable para la revisión, sobre todo para nosotros que siempre estamos viendo la defensa de derechos, ¿no? Derechos por civilización. Uno de los casos que recoge en ese documento es el caso de la comunidad nativa Puerto Blanco, el pueblo Quito, que es el pueblo de Perú, que está ubicada en el departamento de San Martín. Lo que ha logrado esa comunidad es un precedente muy importante. Y es que la comunidad nativa Puerto Blanco y su delegación representativa, que es el Consejo Técnico de los Pueblos Quichuas de la Amazonía, presentaron una demanda de amparo ante el juzgado ministro de Villavista en el departamento de San Martín en el año 2000. Esta comunidad tenía muchos años de creación, estaba ubicada en el departamento de San Martín, tal como ya lo mencioné. Sin embargo, no había sido titulada. Ha pasado mucho tiempo y la institución correspondiente, que es la Dirección Regional Agraria del Gobierno Regional de San Martín, no hizo el trámite de reserva. Estos años ya la sentada la comunidad, sin embargo, no contaba con los documentos que ellos necesitaban en el primer momento, ¿no? Segundo, ellos venían exigiendo, sin embargo, el gobierno peruano, el Estado peruano, no hace caso omiso de esta solicitud y más bien en lugar de ello crean un área natural protegida, la cordillera Parque Nacional Cordillera Sur, dentro del territorio de Puerto Blanco. Tercer punto es que a partir de la creación de este área natural protegida empiezan a restringir el acceso a los recursos, ¿no? Empiezan a controlar sobre el uso del territorio, sobre el uso de los recursos. Los que conocen cómo funciona UNDRIP saben todas las limitaciones que impone. Imagínense ustedes, ese área que está dentro del territorio comunal. Los comuneros de Puerto Blanco no podían cazar, no podían ir a pescar, no podían hacer uso de los recursos, tal como ya lo había hecho durante muchos años. Y no solamente eso, sino que el Estado peruano empieza a dar en concesión a concesiones forestales, se le llama, y también crear bosques de producción permanente precisamente para seguir dando derechos sobre este territorio a terceras personas. Con todo ello es que esta comunidad presenta, como ya les dije, esa demanda de amparo en 2020. Y me sorprende que este juzgado realmente esperaba que se lo iban a declarar fundada, pero sorprende que hayan declarado fundada casi en todos los extremos. Y la sentencia ordena que el gobierno regional de San Martín, a través de la Dirección Regional Agraria, empiece la titulación de Puerto Blanco. Esta sentencia es reciente, si no me equivoco, es de abril de este año, 2023. Y realmente es un precedente muy importante para nosotros, pero no solamente en el caso de Puerto Blanco. Hay muchas situaciones de comunidades que están viviendo la misma situación. Que se crea un UNDRIP cerca o dentro del territorio de política, sin consulta y sin siquiera sin considerar nada. Y es que si se crea un área natural protegida, que justamente es para proteger ecosistemas, no deberían contravenir contra derechos de pueblos indígenas, ya que nosotros somos los principales protectores del medio ambiente. Y sin embargo, estas creaciones que hace el Estado para controlar sobre los recursos están generando muchos problemas en nuestros territorios. Sobre todo porque empiezan a contravenir nuestros propios sistemas de subsistencia, ¿no? Que no podemos ni pescar, no podemos ni hacer uso tradicional de los recursos que siempre hemos hecho. Esta sentencia que da el juzgado en uso de Villavista pues reconoce la titularidad que tiene esta comunidad. Y yo creo que lo que hay que destacar no es que sea por primera vez que se reconoce el derecho, y así ha estado también saliendo
no es que reconociendo, sin embargo es necesario recordar que en reiteradas jurisprudencias la Corte Interamericana de Derechos Humanos ya ha reconocido la titularidad de los pueblos indígenas sobre estos territorios ancestrales, sin necesidad de tener un título de propiedad, ¿no? Tal como por ejemplo, el caso Jurisprudence de Brasil señala que la posición tradicional de los pueblos indígenas sobre sus tierras tiene efectos equivalentes al título pleno que otorga el Estado. Y segundo, que es la posesión tradicional otorga a los indígenas el derecho a exigir el reconocimiento oficial de propiedad y su registro. Algo que me gusta recordar, que dice, por ejemplo, esta sentencia de la Corte, es que no necesitamos muchos los pueblos indígenas de repente tener un documento, ¿no?, que oficialice nuestra propiedad. Es que el hecho de tener posesión sobre ello ya nos hace propietarios. O sea, entonces eso es lo que reconoce esta Corte. Sin embargo, los estados pues, no están reconociendo ese derecho, ya existe, ya está ganado. No es que no por eso. No son cosas en las que recién están luchando, ya están ganadas, gracias a los ancestros que han sido los que han batallado por esos derechos, ¿verdad? En ese sentido, para nosotros consideramos que es una gran victoria del movimiento indígena, sobre todo el movimiento indígena peruano. En realidad, como lo decía, considero que es un gran precedente, un gran, seguramente de ahí podemos cogernos para luchar también por los derechos de otros pueblos, como ya lo mencioné. Hay muchas situaciones, muchas comunidades que también se encuentran en estas situaciones de contraviene entre ANPs y comunidades. Como que no ya se encuentra enfrentado no solamente con las actividades extractivas, que son una lucha constante, sino también con este ANP, que con el tema de la conservación de los ecosistemas, como que se olvida que en ese ANP existen pueblos, existimos nosotros. Creo que eso no se está enterando, sobre todo el Estado, que creo que tiene muchos intereses en la creación de ANP. En ese sentido, saludo más bien este trabajo que ha realizado UNDRIP. Realmente será un documento muy importante, ¿no? Porque mencionaron que soy abogada, que me gusta más que me digan que soy indígena. A veces uno está buscando, está un caso, ¿no? Por ahí donde encogerse, y en ese sentido, a veces uno busca y encuentra casos aislados, pero si tenemos un documento que recoge varios casos, ya no tenemos que estar aislados buscando, sino que tenemos por el todo. Más bien, sería de mi parte. Muchas gracias por la invitación y una vez saludo de parte de Perito. Gracias.
Thank you, Susie. And I just want to echo something that you said, which is very profound. You know, the court is not there to give us anything, especially with regards to our rights to land. And the case have had a long-standing use and occupation of that land. So we're not going to the court to tell us or to give us anything. We're there to affirm what already is. And so certainly the case of Peru sets a very good precedence that others can use in their own claims. I now want to give the floor to, last but not least, our colleague, Mr. Xanharu. He is a human rights lawyer, also the vice chair of the Lawyers Association of Human Rights for the Nepalese Indigenous People. Xanharu, you have the floor.
All right, thank you very much. Good morning. First of all, I would like to thank the Indigenous Peoples Rights International for inviting me this afternoon. Now, I also like to congratulate Curtis and actually Curtis and I were involved in some of the cases in the international related to Indigenous peoples. But as a practicing lawyer, when I look about the digest, it can be used in various ways, especially in litigating the case of Indigenous peoples. First of all, always as a lawyer, when we bring the cases that we are lacking of that kinds of kinds of materials is really, really helpful for the practicing lawyers, particularly who are litigating cases of indigenous peoples' collective rights in cases. That's the one thing where we can use this basis as I use it. Now, sometimes we don't have enough time to do the resources, and we don't get the right resources, and we don't have time as well. The cases are filing. The number of cases are filing up. And so that kinds of these cases I encourage to those lawyers who are working for indigenous people's rights. This is very helpful too. And that, I'm sure that we are not all lawyers, and it doesn't need to be, we all have to be lawyers, right? But definitely we are human rights defenders. And we are indigenous people's right, and indigenous lawyers, and indigenous leaders, at least. What they call the activists, or what I don't like to say, call the activists, but the indigenous people. In one that any cases that we definitely bring into the court, not only in the court, judicial body, but in quasi-judicial body, maybe in human rights institutions as well. So, for that regard, tell your lawyers, if you are getting support from the lawyer, to use this tool so he or she can litigate or advocate from your behalf very strongly. And also this will facilitate that the institutions as well. Let me share about the truth thesis. Now, I do the court litigation, which is we call the conventional litigation, the conventional lawyering. And I also do the people's lawyering. The people's lawyering means I go with the indigenous community. So that when we talk about people's lawyering, it's not the lawyer, it's the community. Actually, they decide the cases, and they are the deciding factors of the end cases, the community, right? But the challenge is, do they know about this legal terminology? Of course not. The two cases I am going to share about is about the aggressive development. Aggressive development relating to the hydro project. In one case, I'm not going to the detail, but briefly, for the time of interest, I'm saying that in one case, the community and I and we successfully won the cases. The similar type of cases, we did not get a success. The fact was similar, issue was similar, and the problems and everything. Why? You know what? The first case, the communities were very, very aware about their legal rights. They know. So you know what they say that ignorance is law. I mean, ignorance of law is no excuse. That means that if you interpret it in other way, that means everybody needs to know the law. That means everybody is a lawyer. Not only the lawyer who gets a license, who gets a degree, or who wears that, I don't know, in my country, black coats. Neither country, right? So, but you have to understand everyone, every person is a lawyer. To become a lawyer, you have to know about these kinds of laws and jurisprudence. So, I'm sure this diagnosis will be a very good tool to get accurate things about how your case will be decided by the court, judicial authority, or quasi-judicial authority, or international human rights complaint mechanism, how that your case will be done. And if you are well aware about it, it will be much more easier and better in your lawyer, right? So in the first case, these indigenous people were very much aware of their rights. So every time when you go, the company goes to talk to them, they talk like lawyers. They're referring to every article, every section of the law, and they're referring to the decision of the court. Because that's why even I would like to say that for the lawyer, we need to make our indigenous persons a lawyer without degree but without rights, and this digest was the first step for that, right? But the thing is that another area that when I was reading about this digest, of course I can do that sometimes, but at the same time, can we use this digest to our customary judicial bodies? Because now in Nepal, the local government started recognizing indigenous justice administration by enacting the law. But these authorities are not very much aware about these kinds of decision making. But they are doing the decision in accordance with the custom. I'm not saying that they are not doing it, but I'm saying that we educate them, we provide them information. Our justice administration bodies. So I guess that if we can think about in this regard. And another area, last, even if we don't like the law, if we criticize about the court, the judicial body is not. We are compelled to use it. We have no choice, right? But there are values that how we can make aware about indigenous people's right to the justice. I was thinking about Nepal. The UN organized the training for judges and lawyers in Nepal through the UNDRIP. OACs are companies. And these kinds of materials, we use through the UN channel, so it will be much more easier, so they can easily accept it when we bring these kinds of materials. Sometimes they say that, okay, this is independent one. But if this goes through the proper channel, maybe it will be much more easier. So that's why, that's my punchline. You can hear, right, in this body. So at least use these materials in the course of training that is provided by you, judges, and the lawyers. Thank you.
Thank you so much for that, Xanharu. Where I come from, they call us bush lawyers. The ones who don't take the lessons. I also, all the deep reflections are really rich and will help us to improve even further how we provide the necessary tools for everyone. I always say, as an Indigenous leader, to my fellow leaders, carry the United Nations Declaration of the Rights of Indigenous People as your Bible. You should have it everywhere that you are. And at least here when I come to the UN, and if you are here, pick up the little really compact versions of them. So easy to put in your purses and wherever you're going. Because it becomes a useful tool, and the more you engage with it, the more you learn to use it. So thank you for those reflections. I want to now give the floor to Joan to give her reflection on what we have heard, and I also want to then also give her the floor to begin our question and answer session. We have left sufficient time to engage with you, to share your own reflections, and to tell you how to access the digest.
Thank you, Christina. This is just to let you know that this is the launch. It's the fourth edition is now in the website. Unfortunately, we're starting only with the English version, but we're working now on the Spanish and the French version of this report. But just again to highlight, there are the cases here is 1 at the global, 2 at the regional, and 6 at the national level. And for the national level, I just wish to also draw your attention to the decision of the Federal It's a revocation of offshore oil permit due to lack of consultation with traditional owners. This is a good precedent case which we can use, I think, or we can cite when all these mining companies, especially those involved in the transitional mining, which is going to be a huge issue for us, that the court really affirmed the inherent that our relation to our land is important for these kind of decisions, that we cannot isolate our culture to the land. So any exploitation to the land will also affect our culture. So that's a very positive jurisprudence and decision of a federal court, which I hope you will find useful along with all the other cases in the digest that we are launching today. So that's just to mention that it's now up in our website, and please feel free to share this to others as well. Thank you.
Thank you, Joan. I don't know if we have any questions from the floor. If you do, just raise your hand. Thank you.
We have a silent room on there.
Okay.
Cristina, es más un comentario que una pregunta, porque además de aplaudir el esfuerzo de hacer este tipo de documentos que son muy útiles para los pueblos indígenas en todo el mundo, pero sobre todo en América Latina, de donde vengo, este tipo de información termina siendo una herramienta cotidiana. Y lo más importante, porque estábamos hablando de abogados, yo también desafortunadamente soy abogada, y Perú suele bromear al respecto, porque estas herramientas no son útiles solo para abogados, de hecho son útiles para líderes indígenas en su cotidianidad, y eso les da mucho más poder. Pensar que un líder indígena puede tomar un documento como este y dar batallas en sus territorios, por la defensa de sus derechos, por la defensa de los derechos colectivos e individuales de las personas que, como en mi país Colombia, están siendo asesinadas todos los días, personas indígenas, le da mucho valor a este tipo de herramientas. Por eso yo quería destacar la labor que están haciendo. Es cierto lo que dijo Arturo, cada vez más sencilla, y justo eso le aporta una enorme valía en la medida en la que terminamos aprendiendo en la práctica no solo cómo usar el documento, sino cómo tomar otros casos posteriormente y aprender a entenderlos, porque los casos nos sirven en la práctica para aprender cómo las historias de otros compañeros indígenas pueden ayudarnos a resolver nuestros problemas. Es un ejercicio de intercambio de saberes, desde las instancias legales, pero también es un ejercicio de intercambio de vivencias. Y por último, quería decir que al final estos documentos nos ayudan a entender que no estamos solos en nuestros problemas, que no estamos solos en nuestros dolores colectivos. Y es desafortunado decirlo, pero también es afortunado en la medida en la que sentir que no estamos solos también nos da más fuerza para seguir adelante defendiendo nuestros derechos. Entonces, muchas gracias, IPI, por todo este esfuerzo, por esta labor valiosa, y esperamos que sigan habiendo más publicaciones, y voy a esperar la traducción en español para compartirla con mis compañeros en la región.
Thank you for that.
Merci, bonjour à tout le monde. Je voudrais aussi saluer mon collègue qui assez important, aussi important qui, quand je parle, m'aider la protection et la protection de leurs droits au niveau national, régional et international. Je m'excuse, quand j'étais parlementaire, quand je levais le doigt, chaque fois mes collègues parlementaires commençaient à rigoler en disant que voilà, tel comme il lève la main, il va parler des questions de la quelques autochtones. Et puis aussi dans ce genre de aussi, quand je lève la main, quelquefois je commençais par la partie la plus souffrante. Et je demande à ce que ce soit au niveau du commissariat, que ce soit au niveau des chercheurs, que ce soit au niveau des bailleurs, qu'on puisse chercher et à amener à ce que tous les peuples autochtones du monde soient considérés comme des peuples. Je ne dis pas qu'au niveau de la recherche, on oublie l'Afrique, mais c'est peut-être une sorte de consultation qui n'est pas beaucoup plus facile, et surtout au niveau linguistique. Parce que là, il faut chercher un moyen qui faciliterait à ce que tout le monde puisse se sentir bien linguistique. Je pense qu'au niveau de la traduction dans les langues qui n'ont pas été concernées par la publication européenne qui se partagent. So, ces jalons. Merci beaucoup.
Thank you for your comments, and certainly there's a lot of room for improvement. Is there any other questions or comments from the audience? I know we're coming close to the end of our session here, but I'd like maybe to take one more before we invite each other. So, thank you very much. I'm now going to give the floor again to my colleague, Morse Flores, who has been instrumental in helping us to multitask here. We're running live for our audience who are not here with us in person. But I want to give the floor to Morse to close us off.
Thank you, Christina. Colleagues, good morning. I'm the Secretariat of the UN Voluntary Fund, and IPRI has been an incredible partner in this journey. They're very new, but I can tell you that they're already making waves. At least in the work that we do with the fund, when the Board of Trustees, Marjolaine is one of them, decided to ensure that when we bring people to the UN in relevant meetings specific to indigenous peoples, that it's not enough that we bring them physically and that they get to know these mechanisms, but most importantly, that when they come here, that they're ready. Ready in a sense that they would be able to use the same language, or even better language, that they know that these spaces is for indigenous people who are quite new, it's quite scary. And somehow this language is actually being used as a weapon against indigenous peoples if you are not unable to use them. So the board have decided that the voluntary funds shouldn't be seen as, as a travel, I don't want to put it that way, travel fund only, but as a real participation and a capacity building tool. So then we have decided to have a whole package of training, and what we do now is we have a whole year training calendar where we follow basically the calendar of the UN meetings and processes and provide capacity building at least 2 or 3 months before those meetings, so that then indigenous peoples, those who are selected and non-selected, actually we now open the training to everybody basically. They have the opportunity as much as anybody else. We have to democratize those kind of opportunities as well. So we're very grateful for IPRI for being one of our key partners. We have cultural survival as well. We have indigenous peoples. The way we're doing now is we have to ensure that those who are giving training, those organizations or peoples that have lived experiences on those mechanisms and bodies, so that they can really explain and give and share their own take on those bodies, what works, what doesn't work in those mechanisms, and really to ensure that they can maximize, indigenous peoples maximize those. But again, we need tools even to do that. So this publication is very important. We really hope that we are able to put that in 5 languages, because we have capitalized your presence, colleague, when you were here in the fellowship program, and I can tell you, you've seen the quality of the interventions even of our fellows and our grantees. They're very grateful. We had simulated the expert mechanism before the expert mechanism with our fellows, and you see the result. There are people who have come and talked to me and said, your fellows, they've done a very good job in their presentations. So thank you very much. We hope to have more of this kind of publications, but also we have to ensure that other UN agencies are also aware that this type of tools are in place. So maraming salamat ulit and nagyaman lang.
This concludes our session. Again, certainly from us at UNDRIP, we really thank you for coming here to our site event. Please share that this tool exists so that others can know of it. It's on our website. You can learn more about it on our website. Again, we are going to have the translation in Spanish and French very, very soon. We're also working with partners to try to develop easy ways to do searches. So that is forthcoming, allows them to build that infrastructure. But certainly the idea is that we will make it more easily accessible to all. Thank you very much, and thank you for being here.
Thank you.